Go for liftoff in T-30.
Stand by for further instructions, Minnesota Black Robe Regiment.
Secondary guidance systems engaged.
Minnesota Black Robe Regiment, it will be on my mark.
All systems are a go. All systems are a go.
Minnesota Black Robe Regiment, you are over the target. You are authorized to fire at will.
Hey, thanks for stopping by Minnesota Black Robe Regiment. It's TC and Friends Monday Night Musings. And if you notice, it's a new look for TC. I'm not wearing my beanie. I decided because it's, shall we say, the blazing middle of summer, which it's technically not. But I'm trying a new like low lighting option. I was playing around with it, and I'm going to see how it goes. And besides, most of you who are going to watch this are going to be tuning in for my expert guest that I have coming on tonight. Tom Gallagher is joining me. We're going to be talking about jury nullification. I know you guys like that sounds boring as all get out, but it's actually a really important tool for defense attorneys, and it's something that we really need to be looking at, especially the way prosecutions are rising for certain types of people here in the United States. The people who should be getting prosecuted aren't, and those who shouldn't are. And there's a whole slew of things that go along with prosecution and how trials work that are just it's just a convoluted mess. And Tom's going to walk us through that. So if you guys are willing, and I would love it if you are, to share this out, share this with friends, because this is something that doesn't apply just to Minnesota. This applies to everybody in the United States, here in our wonderful republic. And while you're at it, check out the coffee. Coffee got a beautiful case of it ready to ship out to everybody. I got the nice merchandise up here. See, look, it looks so good up there, even in low light. But you can message me at mbrrpodcast@yahoo.com if you're interested in coffee or merchandise, and I can tell you what the cost and shipping will be to you, and it goes to a good cost. And then while you're at it, head over to the Subscribe Star, pick a level of support over there, help me keep the show on the road, so to speak. And so without any further ado, we're going to bring in our guest. Tom, thank you. I was telling you before we started that you always outdress me, and it's not hard to do. I don't have any suits anymore, so.
Well, I don't always wear a suit, but when I'm in court, I do. So
you figured with the topic, you should probably look the part.
Right.
Yeah, there you go. Well, as long as you wear the suit and the tie up top, and if you're wearing like Bahama shorts underneath, that's fine, because that's what nobody ever cares what you're wearing from the neck down anyway. So we're here to talk about jury nullification, and it probably does sound boring to a few people as the words rattle around in their head a little bit, but it's actually a really important topic. And so give us a real, like, a kind of a 10,000 foot overview of what jury nullification is to start with, and then we can get into the finer points of it.
Yeah, I think jury nullification it's hard to really talk about it without talking about that phrase, because that phrase is very loaded. Jury nullification is basically a pejorative that enemies of the jury use to denigrate what it is. So under the American system of law, which is follows a tradition of English law, Roman law, and beyond, Greek law, Athens, right? The jury trial started in ancient Athens, when democracy famously rose and fall, and it rose up and fell down, and several times over and over again. Tyranny, democracy, tyranny. The jury, ever since then, has had the right to determine the outcome of a trial, not only in terms of what happened, but also in terms of what is the law. So the jury is the judge of the law and the facts. In the 20th century, there are certain people who wanted to disempower the jury and to say, hey, no, the jury is there to determine the facts, but not the law. And one of the things that they did was they tried to intimidate lawyers, like defense lawyers, obviously, because that's jury nullification means they're going to nullify the law the prosecutor is using to try to convict somebody of a crime. That defense lawyers shouldn't be allowed to talk about it, and that judges shouldn't tell jurors about their legal rights to come back with an independent verdict. So really, the judges talk about jury lenity in a much more happy way. Jury nullification is kind of something judges, not all, but many judges, at least in the 20th century and 21st century, don't like. So you go to law school, they're going to teach you that jury nullification is a bad thing because juries have too much power, and that's not a good thing because juries are made up of regular people, not lawyers and judges who are kind of the elite.
Let me interject there. So that's literally an argument in law school, is that juries are made up of
No. That's my own commentary.
Well, no, but they may not be
that.
using those words, but that's the implication, is that juries are made up of regular schmucks who aren't educated in the law, and it gives them too much power if they all of a sudden decide they can start nullifying these laws.
Well, I don't think they would say that, but that's my take on it anyway.
Wow, I can't imagine you're just.
They would say something like, let me see if I can.
They would finesse it more
properly articulate what they would say. They would say that jurors are not qualified to understand what the law is because they have no legal education. And the law is sometimes complicated. And the jury could be inflamed by passion. They could get emotional. And, jurors might not be, I'm not sure how they would say it in a politically correct way, but basically the jurors might not be smart enough, because to be a lawyer or a judge, you're going to have to be smarter than average, hopefully.
Boy, I wish that were still true.
To go through all that you have to go through,
Especially with most of the judges I've dealt with.
Yeah. But I think, really, in my mind, the whole topic of the jury trial versus the judicial editing of the trial, it really goes to the core issue of populism versus elitism, or the cultural elites, the people who want to control our society politically. Of course, they have very good reasons for this that would justify doing that. And they feel very good about it. They feel morally virtuous about it. But then there's other people like me who say that populism is a good thing for the most part. It's not always a good thing, but it's usually a good thing because people know how to look out for their own best interests. And I think it kind of reminds me of, if you study economics and the idea that there's a free market, and free market actors, if they're rational and they have information available to them, are going to make good decisions for themselves. I think you could apply that to politics and to, legislation, government, jury trials. The two aspects of democracy, if you will, or populism, if you want to call it that the average person has access to without much effort at all. There's really only two things, and one of them is voting, and the other one is serving on a jury and bringing in a jury verdict.
I'll use a case. I think you and I've last time you were on, we may have touched on this a little bit. But in December of 2021, I sat down for the last couple of days of Lisa Hansen's trial down there in Albert Lee, and the judge in that case was very clear in his instructions before the trial ever started that people like Lisa and I, as I was summoned to testify on behalf of the state against Lisa, which I really ended up not doing anything other than saying, yes, that's my video. But when the judge gave these instructions, it was to people like Lisa and I, and basically to the court right in front of the jury, is that couldn't talk about the Constitution and you couldn't talk about law. So Lisa wasn't allowed in her defense to bring those things up. And then at the end, he gave very clear instructions to the jury that here is what you are allowed to do. You are either allowed to find her guilty according to what the defense or the prosecution has said, or not guilty. And if you need any clarification on what the law says, you need to ask me. Now, of course, I'm paraphrasing Judge Joey, the Honorable Joseph Butel. But to me, that smacked of actually kind of a that elitist mentality of you aren't smart enough to look at the facts of this case, look at the law as it's being used against Lisa Hansen, and say for yourself, I don't agree with how this law is being applied. Is that basically what you're getting at? Is that's kind of the overriding view of the legal system of the court?
That's my personal opinion, you could say.
Yeah, but you've been doing this for a while, so I can't imagine it's just simply opinion.
But I could tell you one thing that might shed a little more light on it. So there have been, I want to say dozens, there may be hundreds of published appellate decisions that say that the jury has the right to determine not only the facts of what happened in the underlying matter that's in dispute during the trial. The jury has to decide, well, so the prosecution says this is what happened. The defense either has evidence of some other story about what happened, or they don't have to. They can just attack the prosecution story. And then the jury can decide what they think really happened. Okay. So that's a description of.
So there's really three options there for them. There's either the defense is right, the prosecution is right, or the jury can kind of come up with their own middle ground on it.
Maybe, yeah. I mean, I think they almost always do come up with their own, version of what they think really happened. Was the stoplight red or was it green when the defendant went through the intersection? Maybe, they have to decide. Maybe one side says it was red, the other side says it was green. The jury has to decide. I mean, that one's more kind of, either or, but a lot of times there are other possibilities. But anyway, so one question that one type of question that jurors are asked to determine is what lawyers and judges call questions of fact. And that is supposed to refer to what happened, what historically happened. That's a question of fact. So we don't really know. We have evidence, and the evidence points in one direction. Some other evidence points in a different direction. So how do we put it all together and come up with what we believe really happened? So that's a question of fact. The jury determines what they think the facts were that actually happened in the case. So then a different type of question is what lawyers and judges call questions of law. So questions of law are, what is the law? So does the law say you can't go through a red light? Does the law say you can go through a red light if you're in a police car with the siren and the lights activated on the squad car? Does the law say that you can go through a red light if your wife's pregnant and she's bleeding and you're worried she might die and you're speeding on your way to the hospital with her? So, it may depend on the facts. And so in the end, we have the laws to guide us, hopefully, about what is the best way to behave. But the reality is, whoever made up these laws was just doing the best they could to think ahead about various situations that could come up.
Right.
But the jury is dealing with a real life situation that already actually happened. So they have to decide what is fair, what is right, what is unconscionable. So they have to decide what is the law. And they also have the right to use their conscience. And they always have since the beginning of the jury trial. And so in the mid 20th century, at least since World War II, judges have basically been telling the jury that, you are here to determine the law, or excuse me, you are here to determine the facts of what happened. But I am the judge. I am the legal expert. I'm here to guide you and tell you what the law is. And actually, that goes back to England. There have been similar struggles. If you read the history of jury nullification, there's famous cases going back to the English jury trials before the United States. And then in the United States, there's many of them as well. These classic conflicts like that, where in England, they actually would put jurors in jail unless they wouldn't let them out of jail. They wouldn't give them any food unless they would come back with a guilty verdict, or until they did. And then the jurors would, they would refuse.
That's a whole different type of jury nullification.
Yeah, that's so it has the spectrum of coercion of juries has been wide. There's a wide range of things that have happened over the years.
Hey, the only people allowed to tamper with the jury is the state. Damn it.
Yeah, could be. But I've never seen even one appellate decision from the beginning of the United States until now that says that the jury does not have the right to determine the law. Every court decision that I'm aware of says the jury definitely has the right to determine the law, but the judge, basically the majority view is that the judge does not have to tell the jury that they have the right to determine the law. So it's sort of like a double standard. Or
say that again. So the jury actually does have the right,
yes,
to determine the law.
Well, actually,
but the judge doesn't have a responsibility to tell them that.
I'll try to. I've seen many court opinions say the following, pretty close paraphrase. They say the jury does not have the right to determine the law, but the jury has the power to determine the law. And then there's people like me saying, well, what's the difference? If I have the power to do something, doesn't that mean I have the right to do it? If the law says I have the power to do it legally, the legal power, isn't that the same as the legal right?
Yeah,
But to them, it's a difference. So that's the justification. They're trying to kind of have it both ways. They think they're trying to find a middle ground between kind of an impossible choice. That's their idea, I think. So,
well, it's kind of, for lack of better terminology, it kind of comes down to semantics too, and they're kind of hoping that they can catch. The way I see it, they're kind of hoping they can catch people out on that one and go, "Oh, well, I don't really have the right. I have the power, but if I don't have the right."
Well, that's why you have the Fully Informed Jury Association, FIJA.org is their website. The whole idea behind a fully informed jury, well, why would a group call themselves the Fully Informed Jury Association? Because what they do is they leaflet and pamphlet jurors on their way into the courthouse. Actually, they give everybody a leaflet or a pamphlet on the way into the courthouse because they know that some of those people are jurors. They don't know which ones. And then those pamphlets have information about jury rights and jury lenity and jury nullification. And they have, nowadays, they have links to websites with even more information and videos about it. And so the reason they do that is because the jurors are not being informed of their legal rights by the judge. In fact, the judge is basically hiding their legal rights from them. So and I believe the courts are doing this. They think of it as a compromise of a thorny dilemma kind of a thing. So on the one hand, the jurors have the right to do it, but we think it's very troublesome, so we're not going to tell them about it. In fact, we're going to punish the defense attorney who comes right out and says it to the jury. We're going to put that defense lawyer in jail during the trial.
Wait, that's happened?
Or maybe after the trial. They would probably wait till the trial was over, and then they would.
On a contempt charge or what?
Yeah, right.
Really? That's happened?
I believe it's happened, yeah.
So I'm going to play the role of an attorney, because I'm it's my show, so I can. So I'm the defense attorney. I'm at the end of the trial. I presented my closing arguments, and as part of my closing argument, I stand up and I look directly at, if I'm not standing already, but I stand up and I look directly at the jury and I say, ladies and gentlemen and nondescript, non-binary individuals of this body of people who are here to determine guilt or innocence, I am here to tell you that you have the power, even if what you believe the state is saying as a prosecution may be somewhat accurate. If you disagree with the law, you do not have to find my client guilty. Even one of you can have that view, and my client will go free if you disagree with the tone, the nature, and the tenor of the law. They have thrown attorneys in jail for that?
I believe that's true. I'm sure the internet can tell you very quickly, but the exact people who that's happened to. But I believe that is true.
Holy cow! On what basis? What basis does a judge have to do that?
I believe it's contempt of court, as you said before, because the judge would first warn you. In order to be guilty of contempt of court, normally they have to give you a warning first, and then you disobey the warning, and then boom, something bad happens. It could be money, it could be a big fine, or it could be jail.
Wow, and so your experience with bar associations, how do they feel about this topic? What are their thoughts,
I think
conclusions?
I think the law profession is sort of it's got a lot of people with a lot of diverse opinions, but it also has a lot of common experience and common tradition and culture. So I think the predominant view is, there's something suspicious about jury nullification, especially that term, because that's the most extreme expression of jury power or juror rights. If you talk about jury lenity is similar to lenience, the word. So jury lenity would include jury nullification in its most extreme form, but it also could include something less than that. So if I have a client who is charged with possession of 5 kilos of marijuana, and I get the judge to instruct the jury on possession of a petty misdemeanor small amount of marijuana, the jury could convict him of the petty misdemeanor small amount, even though the evidence is he had 7 kilos of marijuana in his car. So if they did do that, that wouldn't be jury nullification because they didn't let him off completely, but it's a kind of a compromise verdict. That happens a lot where jurors are like, you know what, we don't think he deserves to get the full fare. We're going to give him a 50% off, or
it's
something like
today
that.
And today only, we are giving you 50% off the charge. That's
yeah. The jurors can do that. They can do that.
But isn't that also part and parcel of how the criminal justice system? And this is, I spent almost 13 years working on the law enforcement end, and we've talked about this a little bit before, as a detention deputy, and I watched this play out over and over and over again, where the law enforcers, the armed agents of the state come in and they throw every charge under the sun that they can think of. I mean, I've seen people with fleeing cases get every single stop sign, every single red light, every single time they've crossed the center line. Like they throw so much, and then the prosecution puts it all up in a nice little bow, and if the person doesn't take the plea deal for all the lesser stuff, they go in and they're, oh, you're being charged with all of these things. And does that happen? Is that kind of a tactic where they are able to present the jury with all of these options, where they don't have to come at them with the most severe, or they could come down to a middle or lower ground charge? Is that by plan?
Sometimes. I mean, so if the person is charged with, let's say, 3 charges, something really big and bad, like 20-year or big felony, 20-year sentence, kind of a smaller felony, 5-year sentence, and then maybe a misdemeanor, charge. That would give the jury the option of guilty or not guilty on any combination, all or none. So sometimes that happens. Sometimes the prosecutor will make tactical decisions, like they're gonna gamble it all and they're just gonna charge the one most serious charge, the 20-year felony. That's it. Either they're gonna win or they're gonna lose. They're gonna force the jury to choose.
It doesn't happen very often, though, does it?
Sometimes they're worried. Okay, we're not sure we can get the conviction on the big one, so we're gonna throw in a smaller one that's like easier for them to convict on. On the other side of that coin, the defense can ask for a jury instruction on what's called a lesser included offense. So, like the marijuana example I gave earlier, if a smaller amount of marijuana is a lesser included offense of a larger amount, then I ask for that instruction. If the judge agrees with me and gives that jury instruction, the jury won't even know if that was a charge made by the prosecutor or perhaps the defense requested that. The jury doesn't know that in Minnesota. But then
is that kind of a common practice that you've observed talking to your colleagues across the country, that it kind of happens a lot in other places?
I think it does. I think it happens everywhere. Yep. I just don't want to say the sun rises tomorrow unless I'm absolutely sure, but I'm pretty sure it does happen everywhere. But
in this day and age, we don't know that the sun's going to rise tomorrow. So
yeah, well, I can't prove it. Okay,
we'll see tomorrow.
Yeah, we'll find out in the morning. But so the jury can convict or bring a verdict of guilty or not guilty on every charge they're presented with. So if they're presented with 3 charges, they've got, 3 times 3 possibilities. If they have 1 charge, they only have 2 possibilities.
So as the jury's, like, I'm leaning into this one, as the jury is sitting there, they're getting their instructions. They're not hearing that they have this power or this natural right, if you will, or constitutionally right. But they're hearing jury charging, of course, which confuses people if you don't understand the legal system. And there's one person in there who's heard about jury nullification. I know it's kind of a, like, as you said at the beginning, it's more of a negative. It has a negative connotation in the eyes of the legal system. But so you have this one person who's heard of jury nullification, and he's sitting there going, I don't agree with this law. And he walks into that deliberation room, that jury room, and they're sitting there, and he's like, I'm not going to find this person guilty. I disagree with this law. Is that the hope of the defendant then, or is there a way for the prosecution to circumvent that person?
Not at that point. I mean, if once deliberation begins, nobody is supposed to be able to interfere with that, and I think that's a crime in Minnesota, probably everywhere.
You would think.
Yeah, it's a crime. I believe it's a crime to interfere with a jury that's deliberating. And it has happened on occasion, sometimes inadvertently, like a deputy who's supposed to be watching over them, talking about the case. They're not supposed to do that. So it's not always, it's probably rare that it gets prosecuted as a crime, but it's not as rare that a verdict gets overturned on appeal because it comes out later that somebody interfered with jury deliberations who was not on the jury.
I'm going to bring up a fictional account, and I think any of us who are, let's see, graduated any time before 1992. I'm just going to go with that one. Any of us who graduated before 1992 from high school probably took a lit class, an American literature class, and then also not only read the play, but then watched the movie adaptation of the play, 12 Angry Men. Is 12 Angry Men a really good example of jury nullification in play?
No.
No. Okay. No,
I don't think so.
I didn't.
I could be
think so
wrong. I
either.
haven't seen it in a while. I
didn't think so either, based on what I remember. Other than there was, the wonderful soliloquies of the protagonist.
I think the one thing about that film that usually is criticized for by legal professionals is the idea that I believe the jurors kind of recreated what happened on their own, which is not supposed to happen normally, at least not in the modern context. But I don't think that would be nullification. I think they just felt like there was reasonable doubt that the kid was guilty.
So that's more of an example of what reasonable doubt looks like.
Yeah.
Okay. I asked just because it's the most poignant jury-based movie that I've ever seen or literature I've ever read, because I can't think of anything else that would ever even come close to even touching on this topic. As far as
I think another example,
culture.
I read a decision, I think today. I read part of it. I kind of skimmed over it fast, but
he was doing prep for the show, folks.
There's an Eighth Circuit decision that came out just a couple days ago, I think, talking about where the defendant was convicted. I'm not sure. I think he was convicted of some gun-related offense and sentenced on it. I think it was more than one offense, but one of them was, I believe it was prohibited person in possession of a firearm because he had a prior felony. And the prior felony was, if I remember right, it was possession of marijuana. And so his lawyer argued that was unconstitutional under Bruin, the recent U.S. Supreme Court decision that said the Second Amendment, that there should not be a balancing test anymore about whether the justification outweighs your right, because it's your right. It shall not be infringed. Instead, there has to be a historical analysis about, what did, at the time of the Constitution, was this type of infringement accepted or not? And since there were no drugs and marijuana and alcohol and coffee, none of those things were illegal before the 20th century. And so obviously at the time of the Constitution, they were not illegal. So you could not be disbarred from your right, your Second Amendment or your natural right to firearms and self-defense and defense of country because of a nonviolent crime, possession of a contraband substance. So the Eighth Circuit said, nope, we're not buying it. But if I remember right, there are other circuits that have said, no, that is unconstitutional. But one interesting aspect of that case is that the defense argued that the defendant's rights to a jury trial were violated because the jury should have been allowed to decide whether or not that prior in fact, stripped him of his Second Amendment rights, when in fact it was a
Interesting.
nonviolent offense.
So that was the defense actually in the appeal arguing for jury nullification.
No, not really jury nullification, but
Lenity.
basically they were arguing that the jury should have had the opportunity to um, basically know the whole story, to know the full truth, and to weigh in on whether they felt the law was valid. Which, so I guess that's pretty much related. It's similar to jury nullification, but I don't think it's quite, because it was a question about a prior, whether his rights, because if he was basically they were saying the jury should have the right to decide whether he was a prohibited person or
So
not.
so what this really looks like is ultimately you don't need an entire populace of a potential jury pool to have even dwelled on this thought much, because I mean we no, I shouldn't say we all have, but I mean I just had a jury summons at the end of the year last year, and it ended up not going anywhere, but I had already sealed in my mind that depending on what kind of case they may call me for, I was going to be digging into the idea of whether or not not digging into, but wrapping my mind around from a natural rights perspective and a constitutional law perspective, whether or not I even agreed with the law that the person was being charged with. You don't need a whole jury full of people like that. You only need one.
Well, yeah, I mean, in the sense that you can a hung jury let me back up a minute. In a criminal case in Minnesota, the jury verdict must be unanimous, whether it's guilty or not guilty. So either guilty or not guilty, those are the two possible verdicts, and either one of those must be unanimous. So if 11 out of 12 say not guilty, it's not a verdict. It's a hung.
It's
It
a
could
hung jury.
eventually become a hung jury if the judge, gives up on them. The judge may make them sort of like the old English case where they lock the jury up with no food and water for several days, and then actually the townspeople were sneaking food and water into them, like up a rope in the window, that kind of thing. But it's a fun story. But they may keep the jury, maybe the juries, they're not being sequestered usually. They get to go home, but they're having to come back every morning, to deliberate for how many
Right.
days before the judge gives up. So eventually the judge may give up and say, okay, it's a hung jury, it's a mistrial. It's what we call it.
Right.
Hung jury is kind of the colloquial term. But so if there's a hung jury or a mistrial, then the prosecutor can put the guy on trial again if they want to.
Yeah, well,
But
we saw
that's
this.
still,
We
but I
saw
think
that
that if,
play out in Olmsted County with the gentleman here several years ago that made a self-defense plea in shooting and killing an assailant, and the jury could not come to a decision. And I think they tried him twice down here in Olmsted County, and they still couldn't get to a conclusion. And the county prosecutor, the lead prosecutor, said, county attorney said, no, we're reserving the right to bring this back to trial at a later date. And so far they haven't, several years later. But but what you were describing here with Minnesota's perspective on this, and I know there are other states that have kind of that mistrial or hung jury standard as well. Is that even?
I think there are some states that don't require a unanimous verdict,
Right,
I believe.
right. Well, only for not guilty. Is there any state that doesn't require a unanimous verdict for guilty? I can't.
I'm not sure. I want to say Florida, maybe. I'm not sure because
Ah,
I kind of stay in my lane in my own state. But
well, I don't blame you. You've got enough of a mess for the legal system in Minnesota to not worry about other places. But as we talk about jury, the power of the jury, the rights or the liberty of the jury to kind of assess whether or not a law is constitutional or even lawful for that matter, is the process of a hung jury the demand of the state to require a unanimous verdict for not guilty? That doesn't seem to me. I don't want to use the word fair, but that doesn't seem very just to me. That seems very heavy-handed.
I mean, personally, I, I favor a unanimous verdict because
Both ways.
I don't think we should be able to convict people
Right.
if there's any doubt that they're guilty.
No, I agree with that part. It's the not guilty unanimous verdict that gets under my skin. And because it to me, it sets the tone of, if you will come to this decision because we're going to make you stay here until you do. And that really sets the jury up for a lot of pressure.
I think it seems like, from what I hear, if a jury starts deliberating and they take kind of a straw poll in the beginning, like where's everybody at? If it's 11-1, it's probably going to be 12-0 eventually. If it's 9-3, it could go either way, maybe. But eventually, they can do whatever they want. The jury is its own body, just like the parliament or the Congress is its
Right.
own body. Your political convention, you can kind of do whatever you want. The first thing you do in a political convention is you adopt rules, like Robert's rules or whatever
Mhm.
rules of the convention you have. So the body can do whatever the heck it wants, which is why most bodies, whether they're juries, conventions, Congress, Parliament, they set up their own rules in the very beginning. And then once they have their rules set up, then they go ahead and deliberate or do whatever their rules say they can do.
If jurors and there again, any law-abiding, good upstanding citizen in their state, Minnesota or Florida or wherever the case might be, if any juror was really to start wrapping their mind around this, and you started to see jurors exercise that power that the courts have determined they have, whether they want to call it a right or not is neither here nor there. And as the jury started to do, if they were to start doing this on a regular basis, and defense attorneys were able to take a step back, take a deep breath, and look at their client and say, hey, plea deals are always bad for you unless they've caught you, literally red-handed in the commission of this crime. Like, there's even as your defense attorney, I'm obligated to make a defense for you, but I'm telling you that they've got the pictures of your bloody hands committing this crime. If we would stop offering plea deals and defense attorneys would stop accepting plea deals, would the legal system, for lack of better terminology, in a state like Minnesota or pretty much anywhere, would it begin to grind to a halt if prosecutors were having to take everything to jury trial, knowing that jurors were educated about the power that they have to nullify a law that they disagree with?
Yes.
I know that's a
But
lot of ifs and dreaming.
I mean,
I'm a
I
dreamer.
guess when you say that, it sort of makes me want to point out that I think jury lenity, jury rights, and when jury power is an issue, it tends to be laws that are controversial, laws that not everybody agrees with these laws. In
Right.
fact, maybe most people don't agree, like say marijuana or guns, for
Right.
example. So if most people think that you have a right to a firearm, maybe we don't want to convict some poor schlub who got convicted of a felony 30 years ago, lives in a crappy neighborhood, and he's got a gun in his nightstand.
Well, let's bring up the
So
example.
technically, he's guilty under the letter of the law, but we don't think this guy should be convicted of a crime. The law is wrong.
Let's bring up the example that we talked about before we started the show tonight. The idea of Minnesota now legalize recreational marijuana usage, cannabis usage here. And the ATF steps in and says, "Oh, ha ha ha! No, you cannot, or you can't own a firearm." Now the federal government steps in. Somebody's there for some reason. They end up becoming aware that somebody's out hunting, and they also happen to be a recreational marijuana user, and they send a federal agent to arrest this person and charge them with that crime. Would that be one of those places where a Minnesotan could say, in our state, it's legal for him to do both. You're saying it's not. We disagree with the law. Whether you like it or not, we're not going to find him guilty on this. That seems to me like that have a powerful impact on the legal system if the accused, the defendant, knew there was a way for them to make that argument.
Yeah, and I think it kind of goes back to that Eighth Circuit case I was mentioning a little while ago, which kind of brings the issue. One issue is, to some extent, jury trials. You're seating a jury panel, a group of people, to watch the show and to critique it at the end. Well, who's the producer of the production? Who's the editor? It's the judge. I mean, the lawyers are trying to bring in evidence, and the judge is saying, nope, you can't bring this in. Sorry, we're going to keep that out. So I think sometimes jury trials, like if you look at totalitarian governments, communist, fascist, whatever you want to call them, they're all kind of the same. These totalitarian governments, they are famous for putting people on trial in public, but they limit the evidence that the public is allowed to see. They don't let anything come in. They let in the approved narrative, the story that the government wants allowed to be heard, because they want to convince or persuade the population, or mainly the population. They don't care so much about the jury because it's a show trial. It's a sham trial, we call it. But in the United States today, to a certain extent, we have the same problem, because as like software writers have a term, garbage in, garbage out, GIGO, I think it is, right? So you put garbage evidence in, or in this case, you don't allow the evidence that one side or the other wants to bring in. So you don't allow the jury to hear the truth, because the jury can't handle the truth. So you don't want to let them hear the truth, right? You want to keep that out if you're the judge. And then the jury they're going to come up with a verdict, but the verdict is based on the evidence. And that's what a lot of appeals are about, saying to the appellate court, hey, this was not a fair trial because I was not allowed to present my evidence. I was not allowed to attack that witness with this true fact that they had a reason to lie, or whatever it might be.
I hear a lot about the exculpatory evidence being withheld by the prosecution these days. I'm hearing this in more and more appeals on like severe not just like petty stuff, but like severe felonies, where prosecution literally had the power to exonerate the accused and did everything in their power to hide it. And it's only through the appeal process and deep investigation that a lot of these people are like, you had this evidence like you had evidence that my client was 4,000 miles away, and they could prove it, but you wouldn't allow that in. You hear that more and more often. You had said something there again prior to us, going live, about the threat of the way the trial system is working today, that you brought up because of my question about the idea of kind of jamming up the legal system with more people demanding to go to trial, which is kind of this punitive measure of federal level and even at the state level of, oh, well, if you're going to push this to trial and you don't want to take this lesser charge, then we're going to smack you with everything we have, for lack of better terminology. And you had that an article to share that I'll put up on the screen here in a second that indicates that the right to a trial is swiftly being eroded. We're on the verge of losing it here in the U.S.
Absolutely.
Do you think all of this plays in? That's why we're not seeing juries being able to make these decisions, because people are just getting bombarded with plea deals, offers for plea deals on the front end. And a lot of times, and I know that that's not how you operate, but there are a lot of public
Well, I
defenders,
think,
especially, who just feel overwhelmed and like, you got to take this deal. This is the best you're going to get.
I mean, I guess I have a political point of view, and not everybody might share my point of view, but
Sure.
I'll articulate what I see. And what I'm leading up to there is the federal government, I think, has too much power when it comes to criminal law enforcement, because before the 1930s, there really wasn't much federal criminal law unless you were on federal land or like a federal park or an Indian reservation.
Right.
But ever since the alcohol prohibition, and then the rise of organized crime, which continued, to this day, in terms of the distribution of illegal products, formerly marijuana, soon to be guns, any prohibition, the organized crime is going to fill the gap for that market. So the federal government has kind of used that as a justification for expanding its criminal law enforcement bureaucracy, and for expanding the federal prison system, the Bureau of Prisons, and federal prosecution of crimes. And the jury trial is more common in state court by far than it is in federal court. In federal court, we have the United States sentencing guidelines. Most states have sentencing guidelines nowadays too, and that's another interesting discussion. But the federal guidelines have, I believe, it's a 2-level reduction in your guideline sentence that determines how much prison time you're going to do. You get 2-level reduction for, quote, acceptance of responsibility. Well, what is that? That basically means that you pled guilty. So if you go to trial and you lose, you don't get that. But if you plead guilty, you get a 2-level reduction in your sentence, which I think would probably be like 6 or 12 months for a lot of, it can vary depending on a lot of other things, but maybe 6-12 months less prison time if you plead guilty compared to if you go to trial and lose. So that's what, in my local area, the defense attorneys, we call that a trial tax. The National Association of Criminal Defense Lawyers, which have that webpage that you're looking at right now, they call it the trial penalty. But whatever you call it, it's the price you pay for having your day in court.
Right.
The idea that you have a right to something means that it doesn't cost you anything because it's yours. You own it. So if you own a car and you go crazy one day because you're upset that a bird, crapped on your car, you get out a sledgehammer and you start smashing your car up. Maybe you're drunk, probably doing this, but you have every right to destroy your own property, right? It's your property. You own it. You may wake up the next day with some regret, but if you have a right to something, you can do with it whatever you want. If you have the right to vote, you can go vote, or you don't have to vote. Or if you do go vote, you can vote for anybody you want. And it doesn't cost you any money. In fact, in Jim Crow South, when they tried to charge a poll tax to prevent African Americans from voting, the court said that's unconstitutional. You can't tax a right, like the right to vote, because you don't have a right if you're being taxed. You don't have a right if it costs you anything. If you have a right, that means it's freely available to you anytime you want it to do with it whatever you will. That's what it means to have a right. So kind of brings to the question property rights, property tax, but that's for another time.
Right.
But in this case, your right to a jury trial, you have the right to make the prosecutor prove that you're guilty with evidence that a judge thinks is worthy of coming into the trial, um, and
And that kind of leads to having a
forcing them to
jury.
try to convince a jury that you're guilty beyond any reasonable doubt.
And
So
that leads to the right of the defendant, the accused, to have a jury that fully understands its rights or its powers to be able to nullify a law if they disagree with it.
absolutely. But I mean, I think with nullification or jury power, especially nullification, I think in reality, we're talking about politically controversial areas. So,
Right.
if we're talking about, you killed your
DUI.
wife,
Yeah,
but it was
right.
self-defense, that's not nullification. Everybody agrees that murder should be illegal and self-defense should be legal. That's not
Well,
really a
I don't know
nullification.
about everybody agrees that self-defense
Just
should be
about,
legal these days.
just about. Yeah, I mean, it's where they draw the line, self-defense when you're like your last breath, maybe, but so some things are more controversial. So if you're a draft dodger and you don't want to go to war because you're against the war in Ukraine, some
Right.
people might say, well, gosh darn it, you should be a draft dodger. That's a bad war. Um, Other people might not agree. But
Right.
so there's some things that are controversial. And when it comes to criminal law, maybe we shouldn't be convicting people of crimes that are controversial, like marijuana or gun crimes.
Right.
But I don't think or maybe draft dodging for controversial wars like Vietnam or Ukraine. I don't know. But I think some things are not that controversial. Like,
Right. A guy who's got his fourth or fifth DUI and takes it to trial every time, and they have him dead to rights. That's not a real
I
controversial.
mean, I think for that type of case, it's really like, is the guy guilty or not? Is there some kind of problem with the evidence or not? But it's
Right.
not really nullification. It's not that we
Right.
think that I'm going to stand up for drunk driving. I think we should all drive drunk all the time. Kind of reminds me of some of the abortion rights activists saying, yeah, I've had 29 abortions and I love having abortions. It's my favorite hobby. So
Yeah.
most people don't really agree with that. Even if they're pro-choice, they don't want to say, yeah, let's go out and have
They're
7
not going
more
to brag
abortions.
about it. Yeah.
Yeah.
So it really comes down to civics and being civics minded, and kind of understanding the role of the criminal justice system from from the streets all the way up to the courts, and understanding the roles of the prosecutor and understanding the roles of the defense and understanding the roles of the judge, and the fact that a lot of people, I'm going to say this maybe in a risque way, but a lot of people kind of even misunderstand the role of a judge in a trial, because a lot of times judges don't even understand their role. And yes, it's their job to judge the interactions of the prosecution and the defense, but judges oftentimes even take upon themselves a lot more power than they would grant to anyone else in the courtroom, when they're really there to act as nothing more than referees in the interest of the defense, of the defendant, of the accused.
I mean, I think that I read
Might be
an
an
interesting
oversight.
book recently. What was it called? Something like Individual Sovereignty in Ancient Classical Athens or something like that. And the lady that wrote it was some, PhD. It was very academic, but she kept referring to jury courts. And I thought, wow, that is genius. I love that. So there's judge courts and then there's jury courts.
Right.
So a jury court would be what we tend to call a jury trial, except
Right.
a jury court in Athens was a trial to a jury. There was no judge that we would think of as a judge. There might be an
Not the
MC.
way we would recognize it. Yeah.
Yeah, the judge might be kind of like the MC, like, okay, you go stand over there. We're going to take a lunch break now. That's about it.
I'm
But basically,
picturing.
the
I'm
jury could do whatever the hell it wanted to
I'm
do.
picturing a boxing arena with
Well,
the
back
judge
in
looking.
Athens, they had over 500 people on a jury. So and they paid them
The
the
polis
average
was the
income in
jury.
that society. So
Yeah.
what, like probably like the equivalent of maybe $40,000 a year, or $50,000 a year. So 500 people were getting well paid to sit through all the jury trials in Athens back then. The judges, there were no judges really that we
Right.
would call. There was some vestigial kind
Isn't
of shadow of what we would think of as a judge.
that to me sounds far superior than in most cases, you know,
Although I
unless you're
think
the
their
guy that
verdicts were majority verdicts, they would put a black or a white pebble into a
right.
jar, and if you got more black votes, you were convicted. If you got more white votes, you were acquitted. But I
Is
think
it
judges, I think they know a lot. They're good, but my personal opinion is, if I was a judge, I would be strongly inclined to give a jury instruction to the jury saying, you have the power to nullify the law. You have the power to come up with a verdict. So even if the prosecution story about what happened is true, if you don't agree with the law about this gun crime or this
you're not
marijuana
obligated to
crime,
convict? Yeah.
you don't have to convict.
Right.
It's up to you. You can do what you want. This is the jury trial. This is not the judge telling the jury what to do trial. This is the actual jury trial, or jury court, as
Right.
this academic called it. But to me, it's not this. To me, I don't think this is really civics. To me, this is not civics class. This is, do you want to be a slave or do you not want to be a slave? Because if you want to be a slave, ignore those chains on your ankles and your wrists. Then maybe you won't feel like a slave. But if you want to be a free person, you need to exercise your power as a citizen on a jury and otherwise.
Exactly, and I think that's why we've kind of come to this strange confluence of events where, I mean, everybody, we hear about big name trials wherever we are. Go back to Kyle Rittenhouse, a couple of years ago now, but um, we hear about these big name trials, whether it's here in Minnesota or California or somewhere else, but you don't hear about the average trial in a small, like I live in Fillmore County. It's the one of the poorest counties in the state, and I know a lot of people that get jury summons, and then the night before they're supposed to show up for jury duty, they call and they check that voicemail, or they go online and they check, and it's like case has been resolved. Case has been resolved. The prosecution in this confluence of events is counting on the defense attorney talking the accused into accepting the deal because it's their best option. And I know that's not the case with a lot of defense attorneys, but not all, I should say, but I know there's a lot of them, especially, the ones that are overwhelmed by an overburdened system because people are being charged with everything under the sun, which is why I think we're seeing prosecutors and law enforcement panic with the legalization of cannabis now. A lot of people are not going to have the same amount of work they did. Uh, they're going to come up with something, but for now, they're struggling to find jobs, especially for
maybe they'll start enforcing violent crimes instead.
Especially for those poor canines in Minnesota that were trained. One of the most asinine things I've ever heard from the floor of the House. But what about all the canines that are they're not going to have jobs now? Hell,
Yeah.
But what's happening is the system is definitely overburdened, but it's overburdened with asinine, sometimes controversial laws that are being charged. And the further we've gotten away from the inception of prohibition of recreational use of drugs like cannabis or psychedelics, the more controversial those laws have become, to where now you are seeing even trad cons or normie cons, or kind of just right-leaning centrists are out there saying, I don't know that this stuff should actually be illegal. And then when you start to tie into it what it allows by way of gun confiscation and criminalization of firearms ownership by somebody who literally just happened to have a substance that the state deemed they shouldn't have, that controversy is really, I think, is what pushed something like the current cannabis legislation that passed. But do you see the system lightening up now, and do you see the jury pool being there again as the entire population of the state? Do you see the jury pool maybe swinging and being a little bit more willing to start executing some jury power, or do you think it's too tightly controlled in the state?
Both probably, or I mean, it's a struggle like it always has been. I think liberty and justice is a process. I think a lot of us have been, at least when I was younger, maybe I don't know how or why, but somehow somebody taught me, and I believe that America was the land of the free, and it's justice and liberty will reign forever. And
Yeah.
aren't we lucky ducks, and all that. But and that's not true. It's not like a product or an end outcome that you can ever count on being there. It's something. To me, it's like the head of lettuce you buy at the grocery store. You put it in your fridge. A week later, it's going to be rotten. You got to replenish that. You've got to replace it. It's a process. It's an ongoing process. I mean, life. It's like life. You're gonna maintain the level of quality in your society that you put the effort into. It's not going to happen by itself. If you're lucky, someone else is going to do it for you. But guess what? You're an adult now. That's you. It's not going to happen unless you make it happen. So, the phrase you hear sometimes, the government operates by the consent of the governed. Well, does that mean that we, the governed, are giving a blank check to the government to do whatever the heck they want to us, whatever they want? No, I think what it means is that when we, the governed, disagree with what the government is doing, that it's within our right to ignore them or to overthrow them with guns. That's the right of revolution.
That's just crazy talk.
I mean, that's the basis for the United States Constitution. The Revolutionary War was premised on exactly that. If you look at the Declaration of Independence. So this is not, some people call it civics class because when I was a kid, they made it seem really boring. Hopefully, maybe they tried to defang the truth. George Washington was an ass kicker who killed people with guns, so they want to make him look really cute and quaint and all that. But no, I mean, this is revolution, but it's not revolution like Che Guevara, murdering gay people or something. Yeah. This is revolution of the Age of Enlightenment, overthrowing monarchy,
which is why I always stress to people, like, it wasn't actually a revolution. It was a war for our independence to recapture what was naturally ours, which is, ultimately what grants the power of secession and grants the power of nullification, is the natural right of man.
Right. I mean, it kind of reminds me of, the American legal system comes from the British. The British
English common law, yeah.
The British, you can trace that back to the Roman very strongly. And in the Romans stole majority of what they got from the Greeks. They just kind of made it a little bit better.
And the Greeks just made it up.
The Greeks kind of made it up through hard experience. If you look at Athens, they went through a lot there, Yeah. But they kept trying. But in Rome kind of took a wrong turn with the empire and all that. But
no.
I love the myth of the story of Spartacus. It's reading about that. So there were actually several slave rebellions in Rome.
Mm-hmm.
And one of them had a guy they called Spartacus, and then they kind of converted his legend, and they Romanized the legend into kind of a mythic hero that had all the virtues that Romans thought were virtuous. So the Romans admired the slave rebels, even though they tried to kill them, but they totally admired them. They're like, yeah, that's very Roman that they would, fight for their freedom. So I think, if we want to be citizens and free people, we have to learn about that. What does that mean? So in Athens, ancient Athens, there were three classes of people. There were citizens, medics, and slaves. And the slaves were people who were lucky to be alive, usually, or most of them, because they were prisoners of war who were not put to death. So the lenient, you were, if you lost a war with Athens, they either killed you or they made you a slave. So being a slave was better than the alternative, you know. Then the other type of slave was a wage slave, or no, excuse me, not a wage slave, a debt slave.
Mm-hmm.
Somebody who went into debt and they couldn't pay it back, and they had
Yep.
to work it off in Athens. But so the medic was a foreigner, somebody who was like a permanent resident who lived in Athens. But so the citizen had the right to weapons, property, voting, jury duty, all the civil rights that we have in the United States today, unless we've been convicted of a crime or some other less common situations. But so traditionally, you know, permanent resident foreigners, they did not have the same rights as citizens, of going all the way back to classical Athens. And slaves, slavery was outlawed in the United States. Civil War, you know, which some people call that the second part of the American Revolution. I think I embrace that idea that the American Revolution was not complete until the Civil War happened. But you know, at great cost, of course, because it kind of made us, it strengthened the federal government. But
yeah, that's don't let's know. Don't get me started, Tom.
yeah, I don't want to get you started on that.
A whole
but,
different show. That's
but I mean, I guess what I want to say is, if you don't want to be a slave, you need to know
it requires fighting.
this is not like boring, dusty civic stuff about, you know, fairy tales and the tooth fairy. This is about chains on your feet.
Yeah.
And a gun to your head next to an open mass grave.
Right.
Like the communists have done. So that could happen here at any time. So we have to be on guard for that.
I think that the vast majority of American citizens have no idea how close we actually are to that, the way things are going right now.
And one of the things that stops that is the jury, the right of the jury to have the right of the people and the jurors, both. The defendant and the jury has the right, has rights.
Yes.
And the jury has its own rights, independent of the defendant or the prosecution.
And they have that power, as you said before, because it's a natural right of theirs to look at any law. And I know we've already talked about it predominantly as a focus of controversial subjects, but in any law and say, look, short of murder, short of, you know, harm to another, what's just about this law? What's just? Not what has a previous court said? Well, the Supreme Court's laid a precedence, because that's going to, you know, outside of people like you and me who we're weird. Well, okay, I'm weird. You're an attorney. We're going to look at that and go, oh yeah, well, I don't care what a precedent says. I don't care what a judge says. You know, I don't care what Marbury Madison said. Yeah, there's a couple of great quotes, but was it, you know, a good decision? Those kind of things. The jury has an obligation to look at it from the natural rights perspective. Like you said, take the dry, dusty, boring civics class out of it. The natural rights obligation is to look at this and say, does the state have the power and the authority to take this person's livelihood and life away from them because they've determined it was wrong?
Not only that, I mean, if they can do it to that guy today, guess who they're going to come after tomorrow?
Exactly. Precisely.
The only way to protect you is to protect the other guy, because after they get the other guy, you're next.
Tom, before we wrap up, like I said, we didn't have to go that long, and here we've managed to. I should have you on more often, because then we could just kind of narrow the time, so we don't feel like we have to cram so much into one show. Before we wrap up, tell people a little bit about who you are and where they can find you and what you do.
Okay, I'm Tom Gallagher. I'm an attorney in Minnesota, in Minneapolis, and I have a website, gallagherdefense.com, with a blog. I write a lot about criminal law topics, as well as some more controversial topics like marijuana, guns, other things of that nature. And I'm active on social media, on Twitter.
He is, folks.
as well as Facebook. But I think Twitter is definitely less censored right now.
That is indeed true as well.
Because yeah, I won't even get into that. But and I defend people accused of crimes in Minnesota, mostly in the metro and southern Minnesota, southeastern Minnesota.
um, he's one of those odd beasts like me, folks. Like I've had my opinion change on the cannabis issue slowly over the last decade plus. But Tom, you've been on the forefront of fighting for cannabis legalization in Minnesota for quite a while. You're affiliated with Normal, um, do a lot of work with Normal. And speaking of which, like that your buddy that heads up Normal, I've been trying to get him on. Put in a good word for me. I'd like to have him on. I know you and I talked about it last year, but I'd like to get somebody else on to talk about it. The pros and the cons of the new legislation from someone else, because I know you could entertain us for quite some time on this, but um, so do you see yourself, like, now that cannabis has been legalized and for recreational use and even home growing, by the way, folks, was it August 1st? I think you can. It'd be
August
a
1,
little
2023, and
be a little late to plant your
less than 2
cannabis.
months from now.
A little late to plant your cannabis in your garden in August in Minnesota. That was by design, folks. Uh,
Actually, don't put it in your garden unless you have a fenced, locked area.
right. Or guard chickens.
Well, no, the law actually does specify.
Yes.
It has to be, most people are going to go indoors unless you have
Yes.
a rural area with security, like a tall fence and locks.
Right. Even when they give you the freedom, they don't give you the freedom. But do you see your focus changing, or do you see a lot of challenges to this that you're going to have to be involved in fighting?
Yeah, I mean, it's a huge advancement of human rights and natural rights, and it's going to reduce the government oppression significantly. So there's been disproportionate enforcement against minority people compared to the rate of usage, which is basically similar to the rest of the population, but they have like a 5 to 7 times greater arrest rate. So then once you get a convicted of a felony marijuana crime, now you can't have a gun. So there's a
Right.
racial disparate impact there as well. There's a cascading effect. So I think it's going to help because now there's going to be kids who are going to grow up with fathers in the house more. It's going to be very helpful. But there are still problems because you can't have more than 2 ounces in public under the new law in Minnesota, and you can't have more than 2 pounds in your own home, and so on. And there's a lot more on my website if you're interested in that,
Yeah.
all the details. But so it's not over yet. We still have quite a ways to go.
And the link to his website is in the description of the video, folks.
But on the bright side, you will be able, they say January 1st of 2025, they believe they will have the regulatory system set up so that retail outlets will be, you could walk into a store and buy, marijuana products. Right now, you can buy low THC edibles in Minnesota,
Mhm.
even already. But it's kind of what we have called 3-2 marijuana, 3-2 cannabis. We are actually the last state in the United States that still has a 3-2 beer law.
Yep.
There used to be 2 of them, and now we are the only state that has a 3-2 cannabis law. So something about Minnesota, we like that really weak stuff.
Well, we are the home of prohibition.
I guess so.
But started here, folks. I'm thinking I'm going to have TC's MBRR something. I'm gonna open the first dispensary in my county and work for myself. That's what I want. I don't even use this stuff, but I'll sell it to people.
Yeah, I don't either, but I mean, I think there's already like so many people. I think what has happened in other states is a flood of people come into the market and try to make a go of it, and then only the strong survive, and most of them are going to go belly up. So I wouldn't recommend investing in the industry unless
No,
you
don't invest in the
unless you
industry.
feel very lucky.
No, no. I'd be buying a lottery ticket before I actually invest in the industry. So, Tom, I really appreciate it. And one more time, where can people find you?
GallagherDefense.com or Twitter, Facebook.
Yeah, he's got a
My
couple
name,
profiles on Twitter.
Google.
Yeah, Google. Yeah, Google. Yeah, they
Google
haven't.
likes me, 5 stars.
Yeah, it's because you take the right position on a couple of issues, and then on the others they just ignore you.
Yeah, I mean, I care about people. I've had some people attack me, and then I say, look, I'm just helping people. I mean, people have problems, people go through trauma, people misbehave, and I try to help people get back on track. Or if they're falsely accused, I try to help them vindicate themselves.
That's what we need in attorneys these days. And you have been successful, and I know that you and Normal have been pushing for these changes to the cannabis laws, and it's, as one of the articles on your website says, it's not a perfect law, but it's a step in the right direction. Tom, I can't thank you enough for your time, and I know that you probably had a busy day, and so I'll let you get out of here, and I'll close on my own, because
Thank you.
I haven't ate since breakfast, so I'm going to go do that. So I won't be going on much longer. You have a great night.
All right, you too. Thanks.
Ladies and gentlemen, that's the key is, when we look at these laws that we disagree with, when we look at these things that are controversial, red flag laws, all of this stuff, these things that come at you, um, mandatory mass registration of firearms, all of that. It's I hate to say it, but one of the things that we really had to focus on, and I think it was the Firearms Policy Coalition had said this about Minnesota's new firearms laws. Unfortunately, to challenge these laws, a lot of times you need to find somebody who's willing to be the victim of the law to be able to make headway. What we need to do is we need to start talking to our friends and our neighbors, coworkers, during lunch or whatever, and start saying, "Hey, do you agree or disagree with these laws?" Because here's what happens with most people, especially the conservative, paleo libertarian types, will fight against a law until we're blue in the face. And then the law passes and we go, "Oh, it's the law. I guess we have to follow it now." What Tom and I were talking about tonight is, now you could be on a jury and look at these controversial laws and say, "I'm not going to convict on this." You can, as he referenced a couple of times, lock me in a jail cell and tell me you're not going to feed me until I come back with the verdict you want. I guess you're going to have to be guilty for my death by starvation, because I'm not going to give you the decision you want because I don't agree with the law. We have to take the power back from the state, folks, at any of our levels, whether it's the municipal state, the county state, the state, or the federal state. We have to really start working at taking the power back. That's our job. That's our responsibility. Just like it's the job of the jury, the responsibility, the duty of a jury is to watch out for the accused and do what's right and do what's just. And if a law is unjust, the jury does not have an obligation to honor it. I don't care what the courts say. And that's what the point of something like jury nullification, even though it's kind of looked at as a negative in that terminology, in that vernacular. We have to start thinking about these things. What is liberty and individual sovereignty about, if it's not about protecting the rights and the natural rights of all people around us, even the people we don't like? So, my friends, until next time, head over to my subscribe star, pick a level of support there, help me out. If you like the video, you can share it. I would love if you'd share it. Like the video, drives me up in the algorithm. Head over to Tom's website, check him out, read his articles. His stuff is phenomenal. I don't know how he has time to write the things he writes, because I also know he goes to court on a regular basis. So it's he's a madman, and he makes time to do shows. So he even went on with my friends down there in Tennessee, the Not the Real Libertarian crew, and he made time for them last year. And like, they're from way down there, and bootleg's kind of crazy, and he made time for that. So it says a lot. He makes time for bootleg and me, so that should say something. So go check out his stuff. Pay attention to the laws that are being passed in your neck of the woods, and do the right thing. Stand up for liberty. Stand up for freedom. And until next time, as I say every show, fight for your liberty. It is yours. Fight for your freedom. It belongs to you. And Sic Semper Tyrannis.
We are go for liftoff in T-minus 30.
Stand by for further instructions, Minnesota Black Robe Regiment.
Secondary guidance systems engaged.
Minnesota Black Robe Regiment, it will be on my mark.
All systems are a go. All systems are a go.
Minnesota Black Robe Regiment, you are over the target. You are authorized to fire at will.